Contrary to popular belief, the police do not have to read you your rights when they arrest you. I'm Dan Ringer, and we'll talk about the Miranda Warnings right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
When do the police have to read you your rights? My guest is attorney George Castell. George, thank you for joining us again.
Thanks, glad to be here.
I probably should describe for the audience what you do. You are the Chief Public Defender in Kanawha County, West Virginia.
Yes.
And have been for a while.
It's been 20 years this time.
This time? In your other career, you did it then too.
It's starting to feel like a career.
We want to talk about Miranda warnings. There is, frankly, a lot of misunderstanding, a lot of confusion about what these things are. Who was Miranda?
Oh, Miranda was, the case is Miranda versus Arizona, but he was Ernesto Miranda. He was a person in Arizona who had a troubled life. He had some problems with the law every now and then.
He was a criminal.
He was a criminal, yes, well, yes.
Boil it down to the essentials. Well, what happened that caused this case to come about?
Well, he was arrested for a series of things and interrogated and eventually admitted to a series of offenses. Involved robberies, sexual assault, kidnapping, serious offenses.
One of the things that is true is that lawyers have to take their clients as they find them. Everyone is entitled to an attorney, and so was Mr. Miranda.
Yes. And
one of the issues in the case was whether he was treated properly in the taking of these statements from him by the police.
That's right. The United States Constitution protects all of us from being compelled, being forced to be witnesses against ourselves. And that was the issue in Miranda's case.
The Constitution says basically if someone accuses you of committing a criminal act, it's on them to prove it. It's not on you to prove that you didn't do it.
Yes, and you can't be forced to be a witness against yourself, against your will.
So this case went ultimately to the Supreme Court.
Yes.
I suppose we ought to just pause here for a moment and say what ultimately happened to Mr. Miranda.
Well, he died. He ended up serving 10 or 12 years in prison, was released from prison, and ultimately was killed in a fight in a bar. And the person who was actually suspected of killing him was arrested himself and interrogated, but he asserted his Miranda rights over the death of Miranda himself. And I don't think the case was ever prosecuted because
that's my understanding.
Unsolved crime.
Absent his confession, the person who killed Miranda got off.
Well, you can't even say that that was the person who killed Miranda. There just wasn't proof.
The person who was suspected of having.
And he wasn't compelled to incriminate himself.
So.
And he may not have. I mean, I don't even mean to suggest that an innocent person escaped.
You're speaking like a defense attorney, which is okay because that's what lawyers do. To say that he was the guilty party is to assume a lot more than we can properly legally assume or logically assume.
That's right.
He was a suspect. They attempted to question him. He remained silent. They did not develop any other suspects or any other evidence against him, and they had to let him go, or chose to let him go. We don't know precisely why they did. So the Miranda warnings are what?
Well, there are two main components of it, although it's usually broken into 4 or 5 steps. But the main two are to inform a person that he has a right to remain silent that he doesn't have to be subjected to forced, coerced interrogation. And second, that he has a right to a lawyer, and that if he can't afford a lawyer, one will be appointed for him.
In some versions of the Miranda warnings, and the Miranda warnings vary depending upon where you are or when it is, because these things change over time. Some suspects are told that they have a right to have an attorney present during the interrogation.
Yes.
We do not do that I know of in West Virginia.
Well, what should happen is that the interrogation should stop at that stage if the prisoner, the suspect, asserts the right to a lawyer. The interrogation should stop and should not be able to be reinitiated until he has an opportunity to either retain a lawyer, or if he can't afford one, to have one appointed for him.
So that would kind of anticipate that the lawyer would then do what lawyers do, and typically that's want to be present if your client's going to talk to the police.
That's correct, yes.
What is an interrogation? Logically, it means I ask you questions. Is that the meaning of it in this context?
Well, for the Miranda rights to apply, it's not just an interrogation, it has to be a custodial interrogation, meaning the person has to be under arrest, not free to leave, and be a suspect being interrogated by police. It's not just a casual conversation with the police, or when the police are just interviewing random people at a crime scene. Miranda doesn't apply. When a person's not under arrest, Miranda doesn't apply. When a person's under arrest but isn't being interrogated, Miranda doesn't apply. And those are all common misconceptions that the general public seems to think that a person can't be arrested without being given Miranda warnings, for example. And of course, that's not correct.
And some members of the public think that if the police are going to talk to you, they have to give you Miranda warnings.
And that's a misimpression.
All we know is what we see on Law and Order.
Well, sometimes.
Do you watch the Law and Order programs?
I try not to, because it can be misleading. I mean, I don't want to confuse, and I don't mean to single out any particular television show, but it's tricky, because if you watch too much television, you can confuse the television world with reality. And of course, I'm in court on a regular basis having to deal with reality. I don't want to get trapped into thinking that, oh, wait a minute, on Law and Order, but that was, wait a minute, that was TV.
I tell people constantly that except for this show, television is not reality, it is merely the appearance of reality, and some programs do the appearance of reality very, very well.
Well, and just to reflect that appearance, I want to warn you, too, that you have the right to remain silent. And anything you say on this show can and will be used against you.
It already has been. You're too late. So if I'm at the scene of a crime,
yes,
and I, in fact, committed the crime,
yes,
and the police come up to me and say, who are you? What are you doing here? What did you see? Mm-hmm. They don't have to read me my rights.
No.
Even if I'm the guilty person.
That's right. You're not under arrest, and that you can, and of course you can volunteer anything you want if you voluntarily confess. You know, if you say, I'm here because I did it, I'm sorry. You weren't given your rights, but you weren't required to be given your rights, your Miranda rights, because you weren't under arrest, and the police weren't interrogating you pursuant to that arrest.
That doesn't mean, though, that you might not get into trouble. The example that I always think of and frankly use is if the bank has just been robbed, the alarms are going off, the police is responding, and you're walking out with 2 bags of money in your hand, and the police officer comes up to you and says, who are you? You have to answer that question. They are allowed to ask you mm-hmm. that. They say, did you just rob this bank? There are several possible answers you can give to that question. One answer is yes, because that's true, you just robbed the bank. No, because you're trying to avoid being prosecuted for the crime. However, saying no gets you in legal trouble, because if later it is demonstrated that that was not true, you have committed a crime by lying to the police about your involvement in the crime. And the third thing you're allowed to say is nothing. You have the right to remain silent. Or you could, I suppose, say, I choose to remain silent. And the police cannot use that statement against you because it's not a statement that incriminates you. They have to not leave you alone, but they have to look other places for other evidence.
Yes.
But they don't have to read you your Miranda rights before asking you who you are, or even, I suppose, did you rob the bank, unless you are a suspect at that point.
That's right, and only if the person would then be arrested, which of course, if you're carrying bags of money outside a bank that has just been robbed,
you might be a suspect.
There will be, in legal terminology, probable cause to believe that you've committed a crime and to justify the arrest. And even then, there is not a requirement that Miranda warnings be given, only if police then begin to interrogate you.
Oh, wait. I see on TV, so I know that it's true, that as they're arresting you, they're supposed to give you your Miranda warnings. As they put the handcuffs on you behind your back, they're supposed to tell you that you have the right to remain silent, you have the right to an attorney, and all that.
And that's a misunderstanding. That's not a requirement. The Miranda warnings don't have to be given because there's an arrest. There has to be two things. There has to be an arrest and an interrogation, so that if the person's just being arrested, Miranda warnings aren't a requirement. If he's been arrested and then the police want to interrogate the person, the Miranda warnings have to precede the interrogation.
By how much?
Well, it doesn't matter if they, well, actually it matters. As of this month, it matters, because one of the very newest United States Supreme Court rulings regarding Miranda answers the question, what happens if a person asserts his Miranda rights, asks for a lawyer before any further interrogation takes place? Does that last forever? Or can the police come back at some later date when they have more information and say, hey, we'd like to talk to you again. Are you willing to talk to us now? And of course, the recent ruling of the United States Supreme Court was that if there's been more than a 2-week break in custody, that if the police get new information, they can try again. That assertion of the right to a lawyer before being interrogated doesn't last forever. It lasts for 2 weeks. Odd ruling, but that's...
And there is nothing in the Constitution or in prior case law or in the statutes that gives any indication that this 2-week period is the right period.
No, it was a conservative court, and it was Justice Scalia, a conservative justice, who wrote that opinion, but it can probably be criticized as being legislating from the bench or the product of an activist court, because the 14-day time period was a creation of the court, not a legislator or not something that's in the Constitution.
The facts in that, the relevant facts in that case, was that the police had a suspect, they had him in custody. I suppose it was a him, I say that.
Yes.
And they wanted to ask questions. So they went to this person, or they had this person, and they said to him, you have the right to remain silent, you have the right to an attorney. And he said some version of, okay, I'll remain silent and get me my attorney. 2 weeks then passed.
Actually, in that specific case, it was 2 years.
2 years passed. And they came back to him and said, we want to talk to you again. And I don't know if they read him his rights the second time. But the question became, hey, he already invoked his right to an attorney. You didn't get him one. What are you doing questioning him again? It's been however much time it was, 2 years or whatever. And the court said, no, you're allowed to do that. Once he, quote, lawyers up or exercises his right to remain silent, you can't talk to him until some time has passed. And the question then became, how much time? And out of the air, out of whole cloth, they decided 2 weeks.
Yes.
And that's the rule now.
Yes.
That does not mean, however, that you can't confess.
Oh, that's right, because it's a totally different playing field, and the requirement of Miranda warnings don't apply if a person just volunteers information. If a suspect on his own just says, he's been arrested or not been arrested, doesn't matter. But if he just volunteers that, okay, I did it, I know I did it, I did it, I might as well say so and clear the air and serve my time and get on with my life, Anybody is welcome to voluntarily confess at any time.
Or inadvertently confess. When the
Yes.
cop stops you on the steps leading into the bank and says, "Who are you?" If you say to the police officer, "Here, hold these bags of money I just stole from the bank while I get my driver's license out," that's a confession.
Or what happens a lot of times is because in most jails, well, all jails in this state, all throughout the regional jail system, all prisoner telephone conversations are recorded. The prisoner can then be on the telephone speaking to his girlfriend, and that will be recorded. And that counts as an admission, as a confession that can be used against him. No Miranda rights apply. The girlfriend accepting a collect call from the regional jail doesn't have to read Miranda warnings before her boyfriend can say, "Boy, I really am in deep trouble this time," and proceed. So that is, I mean, that's a confession that can be used against, and often is.
You have no right of privacy when you're in jail or when you're in prison, and oftentimes an inmate at a jail will talk to his or her fellow inmates about what they're in for, and those fellow inmates seeking an advantage will then go to a guard and say, "Mr. Castell there just confessed to robbing the bank," or whatever it was.
And sometimes honestly, sometimes dishonestly seeking an advantage, so that statements given by jailhouse informants, some people think are just inherently untrustworthy.
In fact, in the law generally, if the police are going to react to a statement given by an informant or by somebody that they don't know, there is supposed to be some demonstration of reliability as to the accuracy of that statement. And when you're dealing with informants, the question becomes, well, have they ever given you other information, and has that other information been proven to be true? Is that a reliable informant? And of course, defense attorneys always say, well, of course he's not reliable, he's in prison, he's a criminal. It turns out...
And in many instances has received favorable treatment
Yes.
in exchange for implicating someone else honestly or dishonestly.
Yeah. So those things are viewed with some skepticism by the court system, but they're not automatically dismissed out of hand.
Oh no, there's lots of convictions based on, sometimes based almost solely on the testimony of a jailhouse informant, and a lot of wrongful convictions because of that too.
When would I know I'm in custody?
Well, it's a tricky question. There's a lot of situations where it's really not clear. Because, for example, if I as a law enforcement officer would say to you, I need you to come down to the station house for questioning, he could even tell you that you're free to go at any time, but if you're put inside a small interrogation room with 2 officers standing around you, 1 blocking the door, telling you that you're free to leave at any time, and that being the actuality, can be very different things. So that courts look to what they call indicia of custody, because when there are armed guards standing around you, you will feel like you're not free to go, whether technically you're free to go or not. So it's it can be subjective, it can be confusing, it can be unclear, and there's a lot of litigation over whether this was a custodial, particular instance was a custodial interrogation or not. Sometimes it's not clear, and it can be argued from both sides. And of course, the reason it matters is because if it was a custodial interrogation, Miranda warnings have to be administered before any inculpatory statement can be obtained. If it's not custodial, they don't have to be. So it's often an important issue, but not very clear, because whether you're in custody or not can be ambiguous. Even when you're driving down the highway and you're stopped for speeding, while you're being questioned by that officer, are you under arrest or are you not under arrest? Well, in some senses you are, some senses you aren't. You're really not free to go. On the other hand, you're not, you're not handcuffed. It's just a traffic stop. It's there are a lot of in-between ambiguous situations.
In fact, that case was a case that went to the United States Supreme Court as to whether someone being interrogated or questioned or asked some questions during a stop for speeding or whatever the traffic offense was free to go. And as I recall the case, the fellow inadvertently confessed to something where they found evidence of something in his car, and I guess he had to have said something, And his argument was, they can't use that against me. I was in custody being interviewed by this police officer. They didn't read me my rights. I didn't understand where this was going. And the ruling was, did you try to leave? Did you get in your car to drive off? And if you didn't, then what made you think you were in custody? And an example in a matter that I was directly involved in, although not at the time, I saw my ultimate client was taken, or was met at an airport by a police officer who said, "Come with me." They walked through a security checkpoint, down at least one long hall, past a couple of other security checkpoints, into a locked room where he was seated by the officer at a table with at least one other officer standing next to the door, and they proceeded to interrogate him. And he said some inopportune things about what he had been up to. And the matter went to court. It was in federal court, and he said, I was in custody. They took me past security checkpoints, through a locked door, with a guard on the door so I couldn't leave, and they should have read me my Miranda warnings, whereupon the judge inquired, did they tell you you couldn't leave? He said, well, no. And the police officer testified he could have left if he'd wanted to. So what do you do in those circumstances? The police are talking to you. You feel like they've got you and are not going to let you go. You are going to have to answer the questions. How do you know if you're in custody?
Well, it's a tricky problem, and that's one reason why even there can be a person who is wholly, committed the acts he's suspected of committing. There can be a person who didn't commit the acts he's suspected of committing, and then there's sort of in-between situations where somebody engaged in some wrongdoing or was somewhere where he shouldn't be, where somebody else was committing an act that he maybe can be implicated in, maybe can't. In any instance like that, an innocent person believing in good faith that cooperating with the whole process is the best thing to do can be, misled into doing something, signing something, especially, when you think of what percentage of our population, especially the percentage that seems to get in trouble, are suffering from mental illness, intellectual disabilities, have troubles with the English language, you can see. And wrongful convictions result from that, and there's been a series of notorious wrongful convictions where police have obtained statements in interrogations that may or may not be custodial, but they've obtained, either through sleep deprivation or lack of understanding or mental illness or something, or psychological coercion, or in some instances physical coercion. And that's the reason that Miranda warnings were considered by the United States Supreme Court to be so important, because we do have a constitutional right as citizens to be free from abusive, coercive tactics by any government officials for that matter, let alone law enforcement officers, wearing guns, suspecting us of things that we may or may not have done.
The only way I could think of to determine whether you are in custody is to ask, am I in custody, or try to leave.
Yes, but even then, if you ask, am I in custody, the answer may be no, but the answer may be an illusion, because in reality, as you pointed out, try to leave and then see what happens. And in fact, I have video recordings of interrogations where that's exactly the situation, where the officer said you're free to leave, so the person says, well, then I'm leaving. And of course the answer is, not just yet, you're not.
We want to tell you a few things first.
Yeah.
And this is one thing that I have seen on TV programs where the police sit down and they will say to the person who is in fact a suspect, here's the evidence that we've got, and they go through that and say, this looks really bad for you, and without your explanation of this evidence, we can't help you. It will go very rough on you. And the logical, reasonable thing for most people to do is to try to explain that evidence, try to get themselves out of trouble by giving more information.
Yeah, so what happens, and of course police officers have developed techniques, and many police interrogators have been trained in the use of these techniques, where they recite the Miranda warnings. You have you understand you have the right to remain silent, so just check, you understand that, so check this box that you understand it. In reality, the check means that that right has been given up, not just understood, but given up. But then the police, rather than ask, would you want to assert that right, said, okay, now that we've taken care of these formalities and you've signed the paperwork, let's talk about what happened on Thursday. So that even though, you know, there's an illusion that rights have been given and waived, when in reality, those
It was
rights,
not a knowing waiver.
there was not only not a knowing waiver, but those rights really weren't offered at all. The illusion was created that they were, but in reality, just like the cases I have on videotape, where the officer says, "Are you, you know, you're free to leave," and the client tries to exercise that right, it turns out it was just an illusion. They weren't free to leave.
Of course, as defense attorneys, we're skeptical.
Yes.
George Castell, thank you very much for being with us.
Thanks.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find video of this program at thelawworks.org, and you can find previous programs on YouTube. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.